purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Oh boy, oh boy, oh boy. Other events, what's going on around here? Thursday, May 9th at 7 p.m., I'll be in Franklin County at the 912 Patriots of Chambersburg. That's going to be at the Franklin Fire Company in Chambersburg, 158 West King Street, Chambersburg, PA. I'm going to be talking about your Second Amendment rights, gun laws in Pennsylvania, and all that good stuff. And the Lancaster County Women's Exposition is coming up, and I'm going to be with Mira's Financial Partners sharing a booth down there May 18th. I'll be in there by 9 a.m. and hang around until I have to get back to the show. It's at Spooky Nook Sports. That's at 2913 Spooky Nook Road, Manheim, Lancaster, or however they say it down there. Jay.
Hey, Carl.
How are you?
I was going to call in, but then you got that golf thing going, and I was thinking when I heard that, I don't exactly know what Tiger did, but I don't like it when somebody on TV calls him out or anybody else out for it. You don't see that in any other sport. They don't sit there and say the rules are not,
But golf is a rules,
I know. I play golf.
It's a rules-based game. I mean, so here's what we did to a guy one time. He had too many clubs in his bag. And somebody said, I think Mark has too many clubs in his bag. And I said, of course he does. He always has too many clubs in his bag. Well, what should we do about it? I'm like, well, we don't have to call him on it. Let's wait and see how the game goes. So as we got towards the very end when Mark was up a couple strokes on everybody, I say, hey, how many clubs do you have in your bag? At which time he goes, well, I don't use that one sand wedge. We're like, that's interesting, but you still have one too many clubs in your bag. And according to my little guidebook here, you get 2 strokes per hole, and we can go back up to 2 holes. So it looks like you're going to get a 4-stroke penalty. Now, the reason they only allow you to go back so far is to prevent you from calling the penalty at the end of the round and giving the guy, so many strokes.
You guys are playing with USGA rules and everything.
Oh, yeah.
Of course, you must be pretty good golfers.
No, we're terrible.
Country club golfers.
USGA makes it much worse, too. You can't roll the ball. If it's on a tree root, you got to just smash your club.
I just don't think it's an interested party. A guy has the advantage at home, but he's not a real party to, I know how you feel. I just don't like people. It's just the same thing with the coach at Rutgers. I don't like catching somebody after the fact, so to speak, and putting stuff together and videos going by. But that's not what I called. But
anyhow, yeah, I know.
Rubbed me the wrong way. But anyway, and I also want to confirm that when you put something out on Facebook to stir up the unwashed,
yes,
you're not going to get involved in it, are you? I mean, because I had some stuff this week, but you put it out there, but I shouldn't expect an answer from you on there.
Well, no, but I tell you though, I do like to stir up the unwashed and the washed, and get people thinking and at least talking about things.
Well,
obviously I have a strong.
I assume you read those things too.
Let me explain something to you. Sometimes, just this morning, sometimes people comment on the Facebook post, and I laugh my butt off because sometimes it's so off topic, and you can tell, the Alex Jones fan on there is just trying so hard to get InfoWars out there. I sometimes think it's Alex Jones himself, but but anyhow, it does make for interesting back and forth. And then sometimes when the guys get going and the gals get in there and they start getting some ad hominem attacks, I sometimes will jump in and say, "Come on now, cool it off." But for the most part, I just like to see what the discourse is.
Well, actually, I was going to respond to one guy, and I thought, I want to see what Carl would say. Not because I would respond the same way. I just thought, it's one of these biblical...
Didn't you see my response?
What's that?
Did you see my response?
I didn't.
I said I suggest everybody watch Bill Maher's Religulous and then restart this debate.
Okay. Oh. Listen, what I wanted to ask, it's kind of... now, I was talking to somebody about malpractice, and people do get after doctors, certainly for malpractice, or lawyers for malpractice, and I got a feeling it's more than just I made a mistake or I guessed wrong or something. Can they do the same things for jobs, people like plumbers, carpenters.
You can sue anybody.
You can do it, but is it same? Is it considered malpractice?
Right. So there's a difference between professional negligence and negligence. So malpractice is really just a term for professional negligence. And so if it's a licensed professional, including a beautician, okay, then it's a form of malpractice because they violated the duty of care expected to a person in their profession. And the state requires us to get a letter of merit from another person who's similarly licensed to sign off on it, saying that they did, in fact, commit negligence. On the other hand, if you just hire a guy to re-roof your house, and he's a bad roofer, we don't call it malpractice, we just call it breach of contract.
But it's the same concept.
Same concept, kind of.
Same process?
Same process generally, but the proof's a little different. Breach of contract is this was our agreement and you breached it. Professional malpractice is you breached the contract in a way by not doing things in standard with what a reasonably prudent attorney or doctor or beautician would have done.
What about bad legal advice? Like you're making a guess often that, let's say you're in a criminal case and you suggest the guy cuts a deal because you think the jury will probably find him guilty and maybe he'll get 20 years instead of 30. And, or the other way around,
Right.
And to make just a bad judgment call. Is that the same thing as malpractice?
Not necessarily. The question is, would a reasonably prudent attorney under the same circumstances made the same judgment call?
Okay.
Even though it's bad.
Yeah. All right, well, at least now you know why I don't let the TV cameras follow me on the golf course.
Take care, my friend.
All right, take care.
I think this is Roger.
Hey, how you doing there, Carl?
Good.
I have a question for you. I went through a Superior Court case about 2 years ago, and something's been bugging me I didn't understand at the time with the attorney. We lost the case. He told me it was going to be a hard one. We got this letter that said that we could go in front of the court and present our case for under oral audience, argument or audience. I don't know which one it is.
Oral argument, yeah.
They sent a letter, and they said, well, you can go for 5 minutes.
Uh-huh.
Have you ever seen those letters
Yep.
before? You've seen them before?
Yeah.
Okay. Could I have, do both attorneys need to agree to go in front of the court once they get that letter, or can one of the people who are suing say, okay, I want to do it, and then the other guy has to go along with it? I mean, or who decides whether you actually get the oral argument once you get that letter?
The appellant requests oral argument.
Okay, so if I'm the appellant, if I request oral argument, then which I was, then I could have gone in front of the court if I would have filled it out?
Correct, and then the appellee must show up.
Okay, and then they would have to show up, right?
Yep.
Well, the reason I didn't do it is because when he told me, and he was right. He said, I don't think we're going to have a good chance on winning this, and it's going to cost me a lot of money to go in.
Right.
So you really need to think about it, before you do it. And I really appreciated that. But I never quite understood, why did they give you 5 minutes? I mean, when you get there for 5 minutes or whatever they give you,
mm-hmm.
by the time you put your papers on the desk and you get started telling them.
Well, here's why. Because you don't just go up there and tell them everything you want to tell them.
Okay.
If you ever go up and watch Superior Court arguments or Supreme Court arguments, and I've had the pleasure of arguing the Superior Court a gazillion times and twice in the Pennsylvania Supreme Court, they don't need to hear the facts of the case. So the first thing that a pro se or an amateur will do is or a bad attorney, and I see it all the time up in the Superior Court, they'll get up there and start hammering on about the case, like, well, this case arose when the mother took the child and the father filed this, and then this happened, and then that happened. You don't talk about that. Okay. You walk up and you say, may it please the court, Carl Rominger of Carlisle for Roger. My client raises an issue whereby he was stopped on the roadside without probable cause to do so, and let me explain to you, in the case of Smith v. Commonwealth, blah, 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 and blah, 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 and those are the applicable cases in this case. If the court has any questions, I'd be happy to take them. Otherwise, I'll rely on the remainder of my brief, which time if the judges have a few questions, you go from there.
Okay.
But you see what I mean? In other words, it's appellate advocacy. Generally speaking, the facts of the case have already been decided by the time you're on appeal.
Okay.
So they're in writing. They're in the judge's opinion. They're in the reproduced record. So you're just there to hammer your legal points. However, before I go to break, I'll tell you a little secret. In the meantime, the judges who have studied the facts, and quite often it's very clear they have, may have them wrong.
Okay.
And every once in a while, when a judge regurgitates a fact back to you to sort of try to shoot down your argument and you realize she has it wrong, then if you're really good, you go, well, Your Honor, I heard you say that, but if you turn to the hearing of January 3rd, about halfway through, you're going to see that actually wasn't the testimony, and that's reflected in the footnote in the judge's opinion as well, and then you'll see the appellate judge go, oh, my stupid law clerk.
Oh, yeah. Well, I tell you what, he did me a favor because he said it's going to cost a lot of money for that 5 minutes, and he said, I'd rather just rely on the brief that we filed.
Yeah, and that's not a bad piece of advice. When I come back from the break, I'm going to let you go. When I come back from the break, I'll talk about it for a minute more and then take Harry.
Okay, but thank you very much for clearing that up. Bye-bye.
All right, bye. All right, we're back. Carl Rominger here, 540-0580. I'm just going to say quickly on the appeals, I spoke to a former Superior Court judge, retired, used to be a prosecutor before that, and I said to him, what is the likelihood of influencing you guys on oral argument? And he said when he was on the court, his impression was that the oral argument changed out of maybe, say, 10 to 20 cases they heard in a day. Oral argument would change the outcome of the vote in maybe 1-2 of those cases. And the idea being that taking oral argument's a good idea because if the court's already made up their mind and you're going to lose, maybe, and not that they've literally made up their mind, but they've read the briefs and their inclination initially is to go against you, you may, like I said, catch a misperception of fact and correct it. You may point out a case that the courts themselves have missed or misapprehended and get their mind wrapped around it. And so you can affect the outcome. And I know sometimes it's repetition, too, because I was in front of a judge one time. For 3 or 4 times I filed basically the same motion. I got denied. And on the 5th motion, the judge says, well, what I think you're saying is, and I'm like, yes, why didn't you say that before? And I'm like, well, I think I did. But the point being is you can change the outcome. And so as a general rule, I always take oral argument if possible, although strategically there are times when you go, I'd rather not have to answer any questions about this case because it's sketchy enough as it is. Hopefully the brief's solid enough. I don't want to, get down the rabbit hole, but you should usually take oral argument in most ordinary cases because you could affect the outcome. Harry, I know you've been waiting patiently, and I apologize. What's going on? Harry.
Hello?
Yep. It's you,
Hello?
Harry. You're on.
Hello?
You're on the air.
Yes. I have a question about landlord-tenant.
Okay.
Landlord-tenant.
Yep.
If someone just moves into your unit, no contract, no lease, no illegally,
right?
Do you still have to go to court to get them out?
So they just moved in like they squatted.
Say that again?
They're like a squatter. They just moved in without your permission.
Yes.
You still have to go. You still have to go to court to evict them. Yes.
So they are not like a trespassers or anything?
They are like a trespasser, but we call them a squatter. And if the police aren't willing to remove them as a trespasser, then you have to go to court.
Okay. So my only recourse is to call the police.
Right.
And if the police say they can't do anything,
then you go to the district judge.
Okay.
Okay?
All right. Thank you.
Good luck, Harry. Thanks for holding so patiently. 540-0580. I do want to take one question from Facebook here. Oh, boy, oh, boy. What did she ask me here? Oh, about juries. And speaking of juries, is it a good idea, in your opinion, to allow members of the jury to question the court players? Been watching the Jodi Arias trial and appreciate some of the questions coming from the jury. But if I were a lawyer in the case, I'm pretty sure I'd have a different opinion. Well, Carol, here's the answer. I think it's really a great idea that jurors be allowed to ask questions. Particularly, if you look at it this way, in criminal cases, a lot of times the defendant starts out behind the 8 ball because half the world out there just assumes that in order to be arrested, you have to be guilty of something. And they figure the jury trial's a waste of time and it's kind of this Bubba attitude. And so having the jurors ask questions may make them feel more participatory and therefore more willing to just question what's really going on. So I think that may result in a fairer trial. Also, the jurors will pick up on issues that the lawyers aren't fleshing out, but which they think are important to making their decision. And while the judge will vet those with the lawyers, the questions, it creates the ability to probably have a more informed, engaged jury. So I think as a process of justice, as long as the courts and the lawyers remain as a filter against asking impermissible questions. So, for instance, if a guy's up on a drug charge, you can't know that he has a prior drug charge, generally speaking. So the jury, if the juror asked the following question like, what was the confidential informant wearing? That'd be permissible. But if the juror said, is this a second or subsequent offense or something along those lines, and we just say we can't answer that, it's irrelevant whether it's his first, his 10th, or his second. So that's my answer. My thought would be, now, you can imagine, though, the jury coming up with like that fatal question, right? So sometimes prosecutors and defense lawyers miss stuff, and so either side could be confronted with the chance where they've somehow gotten lucky and the defense attorney hasn't asked the right questions and the prosecutor breathes a sigh of relief, or vice versa, and then the juror raises their hand, throws up their question, gives the question card to the judge. Judge looks it over, everybody goes, well, it's a legal question, and then the side that was so proud of themselves for having skated past it goes, well, I guess that's coming out now. So those are my thoughts. Let's see here. Pat, you're on the air. My talk line number is 540-0580. What's going on, Pat?
Well, I have a question regarding divorce.
Yes.
My daughter has been married 35 years to this gentleman, and now they have separated, and they're going to court, and he wants to keep from her all the paperwork, like for income tax and all the things that he handled solely during their marriage. And I told her that I thought if you called the Pathonetary's office or the Recorder of Deeds, anything that has been recorded, she can get copies of.
Right.
Is that correct?
Anything that's recorded is a public record.
That's what I thought. So I can confirm that with her because he's just trying to keep her from having any proof of anything.
Right. Now, has the divorce been filed yet?
Yes.
In the context of the divorce, there are broad powers of discovery where you can use the court mechanisms to force the other side to divulge financial information.
Mm-hmm.
So her lawyer should work on that as well.
Yeah, well, I don't think her lawyer's doing a very good job. This is in the state of Virginia now.
Okay, well, yeah, that's different. So we can't answer questions, but yes, I do know the answer that generally all public records are public in all states, hence the term public record, and land and things like that are generally of record, so that's how you protect the chain of title.
Yeah,
so
that's kind of what I thought, but I thought I'd better check with somebody who's a whole lot smarter than I
am. Well, thank you, Pat, and you have a great weekend.
Okay, bye.
Bye. 540-0580. Bill, you're on the air.
Carl?
Yep.
Hi.
What's going on?
The reason I called in is because I read a newspaper article this past week in the Patriot concerning trees. And you were in this discussion with another gentleman.
Mm-hmm.
Was quoted, and I had a question for you. I don't know where I heard this, and I don't even know if this pertains to Pennsylvania, but my question is, what I heard was that if you have property and you cannot enjoy that property because of a problem caused by your neighbor's trees or something,
mm-hmm.
that he could be forced to take action to resolve that problem. In other words, basically what happened is I bought a house like 10 years ago. The neighbors in back of me had 2 silver maple trees. At the time, they weren't really big. In those, 13 years, they've grown considerably, and they've grown over the property line to the point where they hang over the fence in the backyard over the pool, and they drop all kinds of crap in the pool and in the yard too. And they have not trimmed the trees since I've lived here.
Okay.
And I was wondering what can I do
well,
to have them at least trim the trees back to their property line.
I think if you look back to that article in the Patriot, I think you're talking about the discussion I had with Bob Carey at the Garden Show.
Yes.
Which, by the way, was a lot of fun, and I think you can buy that on PCN, the actual discussion. But anyhow, long story short, you can't just chop the neighbor's tree down, right?
Right.
You can trim the branches that affect you if they're over on your property, but of course you're always in danger of harming the tree. I recommended at that time, and I would still recommend the same thing, which is to go to the neighbor and say, I would really like to trim these trees. They're affecting me. I'll pick up the bill on it, and I'll hire a pro to do it so there's no danger to your tree.
Well, I did that once before. The house was sold when the previous owner of the house in back of me lived there. I went to him and I approached him and had some people come over and trim the trees back. But I thought it was kind of unfair that I had to foot the bill for this.
Mm-hmm. We don't have to, but it's his trees. So the only thing you could do is just cut the portion that's bothering you across your property line.
Well, the trees are actually so big that I could only I had somebody look at it several times, and the trees are so big that they said to really trim the trees well, you would need to get into the tree and get up in it to trim it because it's so high. So, I mean, even if I could trim what I could reach, there's still an overhang, that would drop the berries and leaves and all the other stuff.
Right. So you'd have to, unfortunately, if it's a naturally occurring condition on his property and it falls over on yours, like let's say a branch blows off of his or leaves or seeds fall into your property from the portion of the tree that's on his property, the law really doesn't give you a great remedy. Your only other option is to file a nuisance lawsuit and have a judge require him to maintain the trees.
Okay. So I could talk to somebody in your office about that?
Yep, be happy to talk to you about it.
Okay.
The office number is 241-6070.
Okay.
All right?
Thank you very much.
All right, take care.
You too.
I got to go to break, guys. When I come back, I want to tell you about a great cigar event coming up. Oh, boy. Lindsay Lohan's rehab center will not allow her to take her Adderall. She's going to have to detox completely. Talking about detoxing. Harrisburg Beer and Cigar, it's over on 3842 Union Deposit Road up in the mall there. And they have a location in Carlisle. They're over by the Walmart. That's the Carlisle Beer and Cigar. They have a cigar event coming up at the Harrisburg location. It's the CAO La Travita Wrapped Up Tour with Rick Rodriguez. It's April 20th from 3 to 7. I'm going to try to be there. I think I can be, given the time. So even if I had to work, I can still make it. If you go in ahead of time and purchase any 6 CAO cigars, you can get a ticket. Good for free, 2 free limited edition CAO cigars from Rick Rodriguez. If you purchase a box, you get a La Travita cutter, 20% off the box, and a VIP ticket good for 1 6-pack limited edition. You have drinks, snacks, T-shirts, raffles, and lots of cool swag from CAO. And again, that's a Harrisburg Beer and Cigar at 3842 Union Deposit Road. You can call over there for more details, 541-1341. And they were also kind enough to give me some of those cigars to smoke. So I am going to be smoking one of these CAO La Travitas this afternoon. I've been chewing on it for a while. Those of you who don't know, I tend to chew on my cigars for a while before I light them, which leads to people endlessly attempting to offer me a light, not realizing that my true intent is simply to gnaw on the cigar for as long as possible. Makes for a very disgusting-looking cigar as well. Nonetheless, I am going to smoke that this afternoon, and I will report back on Facebook what I think. I've got the light wrapper, but I also have some Maduros to try as well. So anyhow, I'm looking forward to that, and hopefully I'll see some of you guys there. And as I was saying earlier, they also were kind enough to give me some beers to try, Sam Adams Double Bock and the Yingling Bock. And I've got pictures of those up on Facebook. But if you stop in there and pick up a case of the Yingling Bock or the Sam Adams Double Bock and tell them Carl sent you, I recommend both beers. I was just saying earlier on the show, I'm kind of an IPA drinker, although I like my Weiss beers and my Belgian triples. And all right, I'm all over the map. Same thing with cigars. I like to try all different kinds. The Yuengling Bach is just a great light drinking beer. Take down with a tuna sandwich or something. The Sam Adams Double Bock's a little bit more of a session drink, but it's really good. So that's the skinny. They're not things I would have picked to buy. So that's kind of what I like about this is I probably wouldn't have branched out and tried them, and now I know I like them. So in the future, I'll have that. 540-0580. John, you've been holding patiently. What's going on, John?
How you doing?
Good.
I'm on probation and in Dauphin County Drug Court program.
Okay. Forget everything I just talked about for the last 5 minutes. All right.
Okay, and well, here's what happened. They give us 2 random urine tests a week, okay?
Okay.
And on Tuesday, my probation officer came and picked me up. Usually I go myself to give a urine, but on Tuesday he picked me up and said we have to do a DNA. And I was thinking drug and alcohol. So we get there, and he's like, here, you have to swab your mouth and do the second set of fingerprints for the database.
Right.
And I'm like, thinking to myself, I'm also disabled, so I have a hard time, thinking really that soon. So is that legal?
Did you enter the drug court for a felony?
I was charged with a felony, but I wasn't convicted of a felony. But the charges were, I pled guilty to a lesser charge.
You definitely would have to do DNA for a felony. Some misdemeanors required as well. So I'm pretty sure that's correct. So I don't know why they wanted to do that. Or maybe that's a condition of drug court.
Well, I talked to other people, and they said they never had to do it.
Did you ask why they wanted to do it?
He didn't really give me a choice to read me any rights or anything.
Well, he didn't give you any choice, but let me ask it this way. Why don't you ask him now? Instead of calling me, call him up this week and say, hey, I'm just curious. Why did we take my DNA?
Well, yeah, and then he was like, then I told him, I was like, after I figured out what was going on, because I'm a little slow, I was like, I'm not a felon. And he was like, well, why don't you tell me this? You know what I mean?
Yeah.
So, my stuff is already submitted into the database. What can I do?
You're probably entitled to have a court expunge it from the database, saying that it was wrongly taken. So you would want to tell next time you go to drug court, tell the judge.
Wait. Okay.
Say, Judge, my probation officer made a mistake. He apparently thought I had a felony and put me into the DNA database. I talked to Carl Rominger on the radio, and he said maybe I should ask you about it. And he said that I should ask you about it and ask what we need to do to get it out since I'm not supposed to be in there.
Right.
And the judge may say, well, talk to your lawyer. You probably, if you had a public defender, you may have to have them file a petition. But because you're going back to drug court on a regular basis, you have access to a judge, which most people don't.
Right.
So bring it up with the judge. And good luck with the drug court. It's a very good program. Keep your nose down and be successful, okay?
So that's not like a violation of the Fourth Amendment or anything?
Well, if it was by mistake.
Okay.
And so let me ask this way. What's your harm?
What's my harm?
I felt a tickling sensation on the inside of my cheek. Okay, that's your harm. Point is, if you get it expunged, there'll be no harm, no foul, right?
Right.
All right?
Right.
All right. Pay attention to your drug court. You didn't even acknowledge that. Are you going to be good and pass this thing?
Oh, of course.
Good.
Of course.
Good. All right, brother.
Okay, thank you.
Probably see him at the beer distributorship when I go down to pick up my beer. Mary, you're on the air. Mary.
Hello.
Mary.
Hello.
Mary, quite contrary.
Hi, how are you?
Good, how are you?
All right. I have a question to ask you. My daughter-in-law purchased a van. She paid $1,500 for it. Now, my understanding is we've been trying to get the title to this van from the guy she purchased the van from. Looking over the paperwork, I wasn't with her when she did the transactions, but finding this out afterwards. When I looked at the title, she has a title. She wants to go down to get the title in her name. He signed his name to it, had it notarized with her name on it. Now, whoever he purchased the car from or before her, he never got the title transferred over to his name.
Right.
So I'm basically stuck with a vehicle trying to get a title transferred. And I've notified him and tried to get in contact with him. I had the van looked over, and it's unsafe for the kids to be even in the van.
Right.
To be on the road. It's really unsafe.
May need to go back to this guy and say, since you can't pass good title, I want my money back and you can have your van.
Okay. Is there anything else I can do as far as trying to file for civil to try to at least, anything? Because right now she's stuck with it. My understanding is that she can't get a title for it.
Right. She needs to go to the district judge and sue him for her money back.
Okay. Does it matter which district justice we go to?
Where'd the transaction take place?
It happened in Harrisburg off of Her Street, and Verback and 14.
So that's probably going to be, that would have been Solomon's office in the day, I think. But I'm not sure.
I'm not for sure if it's Marcia Stewart's or Zozo's.
Yeah, well, check with Marcia first. I think it might be Marcia. Okay. And file there, and if that's the wrong one, they'll let you know and go to Zozo's. Those offices aren't too far apart either. So if you drive the one, it's not like...
it's not a far way to go.
Right. It's not like you're 30 miles out of the way.
Now, I got another question for you. My nephew brought a van.
Oh, no.
25.
From the same guy?
Yeah, no. This is a partner of his. He brought a Tahoe. Ain't had it for 15 days, and the transmission went out on it today. What can we do about that? He paid $25 cash for it. He's got the title. Well, the title wouldn't even come. He just did it over at the notary.
Was that
done.
He bought that from just a regular person?
Yeah, no, this guy here, he goes to the auction and sells cars. I'm not for sure if he has his auction dealer,
right.
His dealer license.
So they probably sold it as is, right?
Right.
Which means you bear the risk of loss.
So he just might as well take a loss. But I thought that at least that he gives him a 30-day warranty after paying $2,500.
That would depend on what their deal was.
What the deal was with him. And see, in my understanding, he didn't have no deal. He asked him for the Carfax for the car to find out, about it. And he said he had it. But he, like I said, that's them not doing their homework and getting that paperwork and looking at it before he gave him the money.
Right.
You know what I mean? I try to teach them to do it the right way because, it's always something that can happen, and this is what happened. So I'm trying to find out. Now, I've talked to the guy today about the van, about the truck, and he's saying that go ahead and get it checked over. Well, we had it towed, and they're going to probably put a new transmission in it Monday. The transmission's going to cost over $800. Would he be responsible for half of that bill at least? If I take him civil?
If it's as is, I don't think so. So it's going to depend on what they're... listen, the answer is, now, if he's operating under a dealer's license, he may have certain obligations to spell that out under the law.
Exactly.
And if he didn't, then he may be responsible for a default warranty, yes.
Okay, that's what I wanted to find out. Thank you very much, and you have a blessed day.
Mary, you too. Thank you. 540-0580, Carl Rominger here answering your legal questions. When we get back, we'll answer a few more. Oh, boy. It's caught this article here about downloading stolen pornography into the Vatican City. It just proves... Listen... I think I heard Rush talking about this not too long ago. The porn industry is like $20 billion a year in America, which is bigger than potato chips, bigger than, you name an industry, it's bigger than a lot of things. I guess gasoline, coffee, and a few things beat it out. But the point being is American consumers spend an inordinately large amount of money on pornography. And there's, of course, 8 billion free pieces of porn on the internet, I've been told. As a result, it makes you wonder because everybody you ask says, I don't buy it. I don't look at it. I've never seen it. Anyhow. Gene, you're on the air.
Hello, Carl.
Yes.
I have a question about the castle doctrine in Pennsylvania.
Yep.
It's my understanding that because of the strict limitations on exercising one's right in self-defense, that it's pretty risky to draw a weapon. Let's assume you have a permit to carry it. It's pretty risky to draw a weapon unless the attacker first draws a firearm or a weapon.
Yeah, that's pretty much because our stand your ground law, says that you have a duty to retreat still out in public. So if you're in your place of business or at your home, you don't have to retreat ever. But if you're out in public anywhere else in the wide world, you have a duty to retreat if you can, unless the other side makes a deadly weapon visible first, and then you may, quote, stand your ground. The problem with that one is, so what's visible mean? You know, the guy was reaching down, looked like they thought he was getting his gun. So here's why it's risky. It's risky because you're going to be second-guessed. It shouldn't be that risky, though, because if you do it right, which is defend yourself, then you're not talking to anybody. You're not telling the police anything. Name, rank, serial number, want my lawyer. Because when I'm done talking to you, we're going to have a little discussion. You know, the police officer says, well, what'd you do? I thought he was reaching for his weapon, so I shot him. Well, were you sure he was reaching for a weapon? Yeah, I was pretty sure he was reaching for a weapon. Did you think about retreating? No, I didn't think about retreating. Okay? There's your wrong answer. I'd say, now, you didn't have time to retreat, or as you look back on this event, as you recall it, doesn't it seem to you that you felt that retreat was impossible? Right? Wouldn't that be the best answer?
Yeah.
See, so my point is, how you articulate it will become what you're stuck with. But if you don't articulate anything, you're not stuck with anything. And I'm not advocating that you lie. I'm advocating that you tell the truth in the manner best for you, just like when the district attorney sits down with a witness. This happens every day, folks. District attorney sits down with a witness and goes over their testimony and says, all right, I hear what you're saying, but are you trying to say this or that? Not telling you to pick one or the other per se, but suggesting that we need to clarify this. The way you're saying it could go either direction. So I think you're trying to tell me this. And the person says, yeah. Then, okay, then say it differently. Say it in a way, and let me give you some suggested ways of saying it. There's nothing wrong with that. That's called preparing a witness for court, helping them understand how to get their version of the facts across. And that's the same thing a defendant should be doing in a self-defense case.
Well, Carl, if I'm returning from a concert in Harrisburg rather late,
mm-hmm.
and we're not talking about one aggressor, but 3 or 4, a gang of young punks,
mm-hmm.
and I'm with my wife,
yep,
and they, by their actions and remarks, I feel threatened. But if there were one individual involved, I wouldn't feel so bad.
But that's your
feel so vulnerable.
Right.
But if there are several, they wouldn't really need to have a weapon.
And here's the deal:
just beat me senseless and attack my wife.
You can still use deadly force in public, but you have a duty to retreat if you can. So just listen to me. You couldn't retreat.
Couldn't retreat, exactly.
And more importantly, you ready? You have no duty to retreat when it's defense of others.
Yes, very good.
So if I was defending my wife. I was most concerned about her. I thought if one of these guys overpowers me, they could kill my wife.
Precisely.
Yep. All right, brother.
Okay. Well, you've explained it, so I need to get your telephone number as my castle doctor and attorney.
My office number is 241-6070, okay?
Very, very good. How about your cell?
My cell number is available. My cell number is available on Facebook. So if you friend me on Facebook, you can get to my cell number.
Excellent. All right. Carl, you've been a great help.
All right, boss.
You've made it a lot clearer.
All right, take care.
For me and for many others.
I hope so.
Okay, thank you.
So keep that in mind, guys. If you friend me on Facebook, you'll find my cell phone number on there. It's public information on my Facebook page if you're a friend. So, of course, we only have room for about 400 more, and then Facebook's going to cut it off. Phil, you're on WHP 580.
Hi, good afternoon. Got a question. A deed of variation on a will that was written in a different country. Would that be recognized in this country?
Yeah, we try to effectuate the will as best we can, understanding that what you meant in it may be influenced by the jurisdiction you wrote it in. But I don't think you can completely trump local law if you die in that state. So to the extent that the will's inconsistent with Pennsylvania law, it's not going to be acknowledged. To the extent that it is, we'll try to give it that force and effect. So it's best if you wrote a will, in a foreign country and you're going to... I always tell people, if you're planning to stay somewhere, that's going to be your domicile, you should write a new will in that state with a lawyer from that state or country in this case.
Well, I guess my question is concerning basically taxes, and the original will. The original will was written, and I don't know why it was changed, but it was, and all the parties concerned wanted to change it back to the original form. And that's why we got a deed of variation. But I guess my question was, as far as the American government goes, which will would they recognize, the first one or the variation?
We look at whatever will was written last in Pennsylvania.
Could you repeat that?
We look at whatever will was written last. In other words, whatever will you wrote last is your will.
Okay.
All right?
Yep, thank you.
All right, good luck. 540-0580. Susan, you're on the air.
Hey, Carl, how you doing?
Good.
My question is a court order needed in order to do an eviction in Pennsylvania?
Yes.
Okay, and what would the qualifications be or the requirements needed to have an eviction?
You need to give the tenant notice of your intent to evict them.
Is there a time frame?
It's 15 or 30 days. And, or what's in the lease.
I'm sorry?
Or what's in the lease.
There's no lease.
Yeah, so then it's going to be 15 or 30 days, depending. Generally think 15 days minimum, but you're on month to month, so you're entitled to stay for whatever month you're in, okay? Then they got to go to the district.
I'm sorry, say that again?
Susan, they got to give you a 30-day notice or a 15-day notice, all right? Got it? Are you writing this down? So after they give you the notice, then they got to go to the judge and file, okay?
Okay.
If you don't get out in the time of the notice. I think this time of year, 15 days is enough.
Okay.
And when you don't leave, then they got to get a judicial order, which means you got to go in front of a judge and have a hearing, and they got to serve you with paperwork.
Okay.
So to evict somebody at minimum, it's about 60 days to 90 days if they don't even put up a real fight.
Okay.
All right?
Very good.
And if somebody wants to evict you, find a new place to live. That's my advice.
Well, and what happens if I was requested to come and stay with my mother to help her recover from surgery for 2 months, and it lasted 7 years because she was so sick? Can they just walk in because they have power of attorney and shut off all your
If they have your mother's power of attorney, they're in charge. But they can't shut off your power and your water and things like that. They have to go through the judicial process.
Okay, so there has to be a court order for that as well.
No, it just has to be a court order to evict you. They can't shut it off ever.
I don't think PP&L got that message just yet.
Well, the short answer is if they shut off the electricity to the place, that's illegal. If you didn't pay your bill and PP&L shut it off, that's a different story.
Right. No, that's got nothing to do with it.
All right.
Power of attorney wants me out, throwing me out.
Right.
Shutting all the utilities off without any court order.
Whoever you're taking care of gave a power of attorney to somebody and said, this person can do what I would do in my stead. So that's the issue.
Very good.
All right, good luck. Let's see. Jeff, you're on the air.
Hey, Carl. How you doing?
Good. How are you?
Question has to do with deed restrictions. Looking at a property. And
shoot fast.
Pardon?
Shoot fast. We're almost done.
Looking at a property, there were some deed restrictions. Can't build fences above a certain height. Can't build barn above a certain square footage. Can the present owner change that deed?
No. The only person that can change it is if all the estates, all the land that was in the original dominant estate, which was broken up into the deed restrictions, undoes it. So that would be the way to do it. But you should consult with a lawyer to look at the issue to see what you would need to do. Got to go? I'll be back next week, guys. Carl Rominger here. Don't forget to stop in at the Harrisburg Beer and Cigars and tell them Carl sent you. Help me out.